When it comes to protecting all of our rights, including but not limited to the right to bear arms, it's critically important that we understand other efforts by the government to engage in overreach that exceeds its powers and authority under the U.S. Constitution. There's one such example when it comes to the appointment as special counsel of Jack Smith, who is doing the bidding effectively of Merrick Garland and going after the Trump administration, Donald Trump himself, and people supporting Donald Trump. Whether you like Donald Trump or not, it's not the point. The point is whether or not Jack Smith is acting constitutionally. And it turns out, thanks to an amicus brief by the former Attorney General for Ronald Reagan, Ed Meese, it may be the case that everything Jack Smith has just done over the last year or two is all for naught and illegal and may not stand. Stay tuned. You're not going to want to miss this when we get back. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a nominee in 2 separate Gundy categories for 2024 for Top Male Influencer and for Top Voice of the Second Amendment. I am proud to achieve and to have received these nominations. Thank you to all that supported me in this endeavor. All right, folks, so this does not specifically talk about the Second Amendment, but it talks about something that speaks to the Second Amendment, which is about government overreach taking away our liberties. Remember, many totalitarian regimes around the world have beautifully written bills of rights, beautifully written constitutions. The Soviet Union had a wonderful constitution in paper. Of course, the reality was there was no way to enforce it. There was no structural means to make sure that the respect for the individual expressed on paper was anything more than a parchment tiger, something that was irrelevant. Well, happily here in the United States, in addition to, among other things, like the Second Amendment and the Bill of Rights, we have a structural constitution which allows for various things to take place that makes it very difficult for the government to take away our fundamental rights. We have things like federalism, where you have states versus the federal governments and states versus the states. We have separation of powers, where the president fights the Congress, the House fights the Senate, the courts fight the presidency, and so on and so on and so on. So it's really good to understand this importance of these kind of difficulties in separation of branches and separation of powers, all of which are structurally designed to slow down the process and make it hard for government to take away our most fundamental rights, found in, among other places, the Bill of Rights, including the Second Amendment. So when you see a case that's going on right now in front of the U.S. Supreme Court about whether or not President Trump has what's known as presidential immunity for his actions on January 6th, a case, by the way, that has just been sent back down to the D.C. Court of Appeals. We'll get to that in one second and why that's so important for our Second Amendment rights. It's very important that we make sure that the government toe the line and respect our rights and be limited to its designated, specific, enumerated powers and does not go beyond that. Because every unconstitutional, illegal infringement on our rights, and by the way, any additional powers that the government takes upon itself is effectively reducing our freedom, because every single bit of governmental power is really an opportunity to take away our rights, effectively or otherwise, whether they intend it or not. So that's what brings me to the discussion today of this major amicus brief filed before the U.S. Supreme Court. Now, it turns out this is moot in the short run because the U.S. Supreme Court has just announced that they are not going to expedite Jack Smith's request to hear the presidential immunity question before the United States Court of Appeals for the D.C. Circuit decides. Now, when it comes to the Second Amendment, this is very interesting because we have often complained on this channel, and many people who watch this channel have complained, and I'm not opposed to what you're saying, that it was wrong for the U.S. Supreme Court to not inject itself and to enjoin various things like the Illinois quote-unquote assault weapon ban when they had an opportunity to, after Frank Easterbrook and Judge Wood screwed up the Seventh Circuit Court of Appeals decision, which effectively upheld in the short run that gun ban in Illinois. But the U.S. Supreme Court refused to get involved, and I've said repeatedly that, like it or not, one of the reasons why I think the Supreme Court doesn't like to get involved with cases prematurely is they don't like to get involved on what's known as an interlocutory basis. They generally like to hear a case after it's complete, or after it's exhausted all of its remedies, if you will, or all of its processes in the lower courts. Well, we have suffered the brunt of this in the last several months, where the U.S. Supreme Court has repeatedly turned down opportunities to get involved with Second Amendment related cases, such as in Illinois, because they're like, hey, basically it's just too soon. You resolve issues in the lower courts, and we'll get to it in the normal course like we would in any other case. We're not going to treat the Second Amendment specially. Now, I think they should because of the nature of the right and the fact of how it's been abused in the lower courts. But the fact is, the U.S. Supreme Court generally doesn't like to single out any one particular issue for preferential treatment. Now, on the good news front, that is exactly what just happened to Jack Smith, who thought by rushing to the U.S. Supreme Court to get the U.S. Supreme Court to take this case on presidential immunity before going to the U.S. Court of Appeals, he thought he could circumvent and expedite and get special privileged treatment by the U.S. Supreme Court in favor of Jack Smith's special counsel office in favor of trying to throw Trump in jail. And I'm happy to report the U.S. Supreme Court has refused to do that. They basically said in a decision, we're going to deny the request to expedite this and take this case now, go back to the lower courts, and you figure it out, and we'll deal with it when the time comes, if we need to. So that sends Jack Smith, the special counsel against Donald Trump, back down to the United States Court of Appeals for the D.C. Circuit, where it will be argued orally in the middle of January 2024. And at some point, there will be a decision by the U.S. Court of Appeals for the D.C. Circuit. And from there, that can go to the U.S. Supreme Court. What this effectively means, of course, is probably the March trial date that Jack Smith is trying to enforce against Donald Trump is probably going to fall by the wayside, which is not a shock. But nevertheless, that's probably the effect of this. So with all that said, the reason why I want to bring this up, and this is quite fascinating, is there was a major amicus brief submitted to the U.S. Supreme Court, which presumably will also be submitted to the U.S. Court of Appeals for the D.C. Circuit as this presidential immunity question, i.e. whether or not President Trump has presidential immunity from prosecution by Jack Smith for the January 6th events. Okay? Now, what this amicus brief submitted by former Republican Attorney General under Ronald Reagan, Ed Meese, said, and this is a very serious brief because not only did Ed Meese sign on to this brief, it was submitted by two very serious constitutional scholars, Gary Lawson as well as Steve Calabrese, one of whom, of course, is a co-founder of the Federalist Society. Neither of these individuals are considered to be partisan in any respect. They're definitely viewed in the legal community as serious scholars. Maybe they lean to the right as conservatives politically as a general matter, but no one would view these people as fire-breathing, right-wing partisans, if you know what I'm saying. So their arguments are going to be taken quite seriously, and the arguments they're making are quite interesting. They're specifically saying that the appointment of Jack Smith by Merrick Garland is unconstitutional because Merrick Garland lacked the authority to appoint Jack Smith to the special prosecutor role, and Jack Smith lacks the authority to do what he's been doing, and therefore all of his work to date should be thrown out on the grounds that it really is what's known as ultra vires, which means it exceeded the scope of any legal authority that he had. And to give you a great quote, and then we'll break down the legal geeky details, the great quote out of the brief says the following, quote, not clothed in the authority of the federal government, Jack Smith is a modern example of a naked emperor. The brief goes on to say, quote, improperly appointed, Jack Smith has no more authority to represent the United States in this court than Bryce Harper, Taylor Swift, or Jeff Bezos. It's powerful language in this brief. So what is the basis for saying that all the work that Jack Smith has been doing on behalf of Merrick Garland as special counsel has no constitutional authority and therefore is basically null and void, ab initio, from the beginning? The first argument they say is that the office that Jack Smith holds does not exist under federal law. He holds a special counsel office, but the independent counsel statute that arguably he could have used, that expired in, I believe, 1999. And therefore, Jack Smith is holding on to an office that does not exist. Because Congress has the sole responsibility for creating additional offices beyond, of course, the office of the president, which is created by the Constitution, and the office of the vice president, which is created by the Constitution itself. Any other offices must be created by law, and who creates law in the federal system? That is Congress. So in the past, we know that Congress has passed laws to establish the independent counsel position, which in that instance, they had authority and the ability to act. But the independent counsel statute, again, as I pointed out, expired, I think, in 1999, and there's been no similar law enacted by Congress since then. So Jack Smith is operating, according to this amicus brief argument, in an office that simply doesn't exist under federal law, which means that everything he's doing lacks authority. So it's no different than when ATF acts without legal authority and you get to ignore it effectively. At least that's the legal argument. If ATF does something that they're not allowed to do, well, that should be null and void ab initio and null and void because they never had the authority to enact it in the first place. We see that all the time under the Administrative Procedure Act, where Congress, I should say, an administrative agency exceeds its authority under the statute that Congress created for it. Likewise, the argument here is Jack Smith lacks this authority. The second point that this amicus brief makes as to why Jack Smith lacks the authority to prosecute Donald Trump, because he's holding an office that doesn't exist. The second point speaks to what are known as superior officers versus inferior officers of the United States. I'm not going to bore you with this technical details, but the argument is that if you are a superior officer, under the United States Constitution, you can be appointed by the president, but you cannot serve unless advice and consent is given by the United States Senate. This is why the president can appoint, for example, Robert Bork to be a federal judge, but unless the Senate confirms by advice and consent powers the appointment of Robert Bork to the U.S. Supreme Court doesn't count. That is why, for example, all the cabinet officials have to go through the Senate, or U.S. ambassadors have to go through the Senate. These are what are known as superior officers of the United States. Not inferior. So you can get a job, you can get a W-2 job with like the Census Bureau as a civil servant, and you're what's known as an inferior officer or an employee. That's fine. But if you're a superior senior officer in the federal government, you have to be appointed by the President of the United States, the executive branch, and then confirmed by the United States Senate through the process of advising and consent. So the argument here is that Jack Smith is functioning as a superior officer appointed by the President of the United States, but he was never confirmed by the United States Senate. So he'd be no different than, say, Robert Bork being nominated for the U.S. Supreme Court by, in that case, Ronald Reagan, but the U.S. Senate never confirmed Robert Bork to the U.S. Supreme Court. So to the extent Robert Bork ran out there and was writing opinions on cases, he could do that, but it wouldn't have any legal significance or legal meaning because he'd be acting ultra vires. He lacked the legal authority to act. Because remember, governments have powers and authorities. They're not always the same. I may have the power over someone. I may be able to kidnap someone or to murder someone, which gives me power over them, but that is different than legal authority. So what's happening here is Jack Smith may be exercising governmental powers over people, but he lacks the legal authority to do it. Never forget that powers and authority are not always the same. People sometimes can exercise power in a way without legal authority. And that is exactly what this amicus brief by Ed Meese and the two constitutional scholars, very well reputed constitutional scholars, are saying that why Jack Smith lacks the authority to prosecute Donald Trump in all respects, and including involving the January 6th. So this is a very significant legal development that has not gotten nearly the press or attention that it should have gotten, and it will get going forward, because if it turns out that Jack Smith lacks the legal authority because he is doing a job that doesn't exist in the federal government created by Congress, or he hasn't been confirmed by the U.S. Senate, then all of his work is going to be thrown into the trash bin of history, and none of it will count because he will have been acting ultra vires or without legal authority, and that will be a very big deal, which means that Merrick Garland will have to go back and do it himself or not. That will be up to him, but obviously all this Jack Smith work will be for naught. We'll see what the federal court does it. We're going to first and foremost see what happens with the U.S. Court of Appeals for the D.C. Circuit, and then, of course, down the road, the U.S. Supreme Court, presumably. All right, folks, hope you learned a little bit something here about the Constitution. Don't forget to subscribe to this channel. Some of you have been unsubscribed, I'm told, so make sure you subscribe if you're not sure, and share and like this video. Don't forget to also follow me on X at 4 Boxes Diner, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.